to order on the Governmental Affairs Subcommittee. And first, I want to hear Representative Oliver, House Bill 66. Would you present that, please?
Mr. Chairman, would you like me to go?
Yes, if you would, please. Thank you.
Thank you, Mr. Chairman, for this opportunity. I'm very much appreciative. I represent an area of DeKalb County that includes 4 cities, 3 independent school districts, and portions of unincorporated DeKalb. We are a comparatively well-off district in Georgia, and there's a great deal of competition among our government entities and a great deal of activity in relation to the creation of new cities, new expanding annexations of the new and old cities, and multiple development authorities. Each of the cities of DeKalb have their own development authority, and there is just a lot of positive activity. There's also a lot of competition. Competition is good, and we have a great deal, though, of conflict that has come with that competition. And I think that the 3 bills I've introduced, House Bill 23, House Bill 24, and House Bill 66, are bills that will add transparency for the public and to other impacted governments in the arena of primarily annexations and development authority tax abatement issues. In addition to transparency, it will, with some of the ideas I'm proposing, eliminate some of the litigation that is going on in DeKalb County that's symptomatic of other issues across the state of Georgia. The major competitions with development authorities, cities, and annexation may be in the urban areas, but it's clearly represents issues across the state of Georgia. There are 500 cities in Georgia, 159 counties, 180 school districts, 21 independent school districts. Development authorities across the state have a lot of impact on how services, money, development moves forward. And I believe that the procedures whereby these progress can be accomplished, can be improved for the purpose, again, of transparency and for the purpose of fair participation of people who are impacted. I pre-filed bills as a routine because I like to tell the interested people what I'm doing and how I'm engaging, and it very helpfully, in this case, for these 3 bills, generated a lot of conversation. I have met with the Georgia Municipal Association, the County Commission Group, lawyers for various parties who have been in litigation over these issues of annexation and bond validation hearings, and generated, I think, a very positive discussion also with the developers who are primarily interested in development authorities and expanding. Chairman has asked me to begin with House Bill 66, and I'm happy to do that. Nowhere in the Georgia Code is tax abatement defined. There is no law in Georgia that defines tax incentives, but there is a statute that's set forth in House Bill 66 that requires that when bonds are issued, that the bonds must be validated. And in the context of the bonds that come primarily from development authorities in Superior Court in bond validation hearings, the statute currently says that any citizen can appear and respond and offer evidence and testimony about the bond validation. But what is happening is that the school systems, who are very directly impacted by development authorities, bond validation, tax abatements, tax incentives, tax deferments, tax benefits for development, the school systems are not allowed in the courtroom. And as that's being litigated in a number of different cases around my area and in Fulton County, the parties of the Development Authority and the school systems in the county are wasting much time and much money on what I consider an unnecessary fight. The purpose of House Bill 66 is to specifically grant standing or authority to participate in a bond validation hearing. In a recent case that's already been decided in DeKalb County, Judge Heydrich of the Superior Court of DeKalb County determined that the DeKalb school system does have a right to come into a bond validation hearing. Some people have argued that since the statute says any citizen, that a school system should be a citizen. But other cases across Georgia have said that's not true. A citizen is different than a school system. If a county commission additionally can be impacted, or other cities can be impacted by these development proposals that are set out in bond validation hearings, similarly, they should have a right to come to court and set forth their own interest. That is the simple, specific purpose of House Bill 66, to eliminate the conflict of who has a right to come to court and participate in hearings of bond validation, specifically grant to, as we say, any local school system or any county or municipal government authority covering the geographic area of the governmental body desiring to issue such bonds. So if Development Authority of Brookhaven wants to offer tax incentives and specific tax abatements in DeKalb County, the DeKalb County school system is clearly a party at interest. And that has been a case that's been recently litigated. The question I've asked a number of the parties I've talked to is, do you want the only dispute process to be litigation? Or do you want to look at ways that we can simplify the rational and fair discussions that can come forward and should come forward for interested individual citizens, but also interested school systems, counties, municipalities, and other impacted governments? If I may, Mr. Chair, I would like to talk about 23 and 24 briefly, because it's a package of bills, and then come back to an amendment that is being offered on House Bill 66 by ACCG, and suggest to you that I'll have testimony in support of HB 66 from one of the DeKalb County commissioners and from one of my DeKalb County School Board members who has felt that the law does not properly grant them enough authority and standing in court on the bond validation hearings.
Before you move on to those, Representative, does any member have a question? Chairman Fleming?
Thank you, Mr. Chair. Madam Chair, how are you today?
Good afternoon.
So whenever I have questions on bonds, I call a bond attorney
Mhm.
because it is confusing. And when you make a mistake, the malpractice suit is for millions. So I'm no expert in this area, although I have asked bond attorneys quite often to help me with stuff. If I understand this correctly, the intervention portion of this, whenever bonds are going to be let, you have to go before a Superior Court judge, and it's basically a hearing. You can even call it a trial. I've seen one that went on for a week one time. And witnesses can be called, and the judge basically has to decide, is this a valid and good bond issuance, or is it going to be a waste of taxpayers' dollars, which would be harmful? I mean, that's pretty much what the intervention proceeding is. Excuse me, the bond validation proceeding, correct?
Yes, sir.
Now, this intervention portion that we're talking about, as a citizen, and let me ask you this question. Usually citizens that are interested are the ones that live in the city or the county. But can any citizen in Georgia walk in? Because where I'm heading is, isn't your school board chairman a citizen?
Yes, yes, sir. And if I see where you're heading, you're going to take up the argument that was taken up between the Fulton County Development Authority and the City of Atlanta school system, whereby the school board member tried to intervene and the judge said, no, you're a school board member. You're representing a school entity. You're not representing yourself personally. So that specific objection or specific route to the courthouse, I think, was slowed very much in a recent case in Fulton County, where I think that litigation was abandoned and ended, so there wasn't an end result on that.
Maybe a more basic question, if I may, Mr. Chairman. What is when the citizen, and I'll use the citizen intervenes, what does that mean? The citizen intervenes in this context. Does that mean that they somehow become a party? Or does it mean that they just get to come and testify? And what are we trying to get the school board to be able to do?
I think that bond validation hearings, which frequently set out a development deal, which tax incentives and tax benefits, have an economic impact on the school system as an entity trying to, in DeKalb County, educate 105,000 children. When a specific recent case that has not in, that's been in front of Judge Heydrich, which is not, I don't believe that case is happening today because that deal was pulled back. When Brookhaven wants to annex high-value commercial properties on its border, it cost DeKalb County School System $7 million. I think that $7 million is a lot of money to me. And what DeKalb County School System would have to say is that the reason this annexation, this bond validation thing is not appropriate is that it impacts us significantly. And there's standards set out in the statutes. There's an arbitration panel that has standards, and then there's a bond validation has standards, and they kind of parallel in some cases.
But my question goes to what is the intervener? It simply is someone who has a right to come in and be a party. Therefore, they now have access to call witnesses and make arguments and file motions in the case. Is that right?
Yes, sir.
And that school board member who was deemed not to be a citizen could only sit in the audience. They could not participate. That's the whole concept here, correct?
I want the school board or the local school or the other cities or the other independent school district to have a right to be in court. It doesn't say they're going to win. It doesn't say they're going to prevail, but they should have a right to be in court, perhaps with citizens, perhaps with other governmental entities. And my school board member and my county commissioner would be happy to, I'm sure, answer your questions also about how they specifically think their interests right now are being thwarted. They're not allowed to be in the courtroom.
Last area of question, if I may, Mr. Chairman. As I understand it, the State Road and Tollway Authority and the Georgia Ports Authority utilize the same law as far as that govern interventions and govern the proceedings where one goes before court to validate bonds. And as I read your legislation, you are going to allow people to intervene into their proceedings as well. Do you agree?
You've raised a question I frankly had not thought about. The Georgia Port Authority issuing bonds to construct its facilities, which I assume is the purpose of issuing bonds. I'm thinking aloud here right now. Does that impact the school system of Chatham County?
Yes.
And
They
if
take
it
land that
if
does.
it impacts on the issue of children to serve, if they are taking in property for issuing bonds then I think they should be able to intervene in a Georgia Port Authority case. I think the analysis may be just as appropriate if it impacts children in a school district, if it impacts the ability of the school system, or whatever, City of Pooler, if it's next door. I don't know the lines down there exactly. If they're impacted by some issuance of bond in relation to a specific project, that's the key. Does the project impact Pooler or Chatham County School System?
I'm always happy to try to help resolve DeKalb problems. We
But-
seem to have a lot of history doing that, but I want to be sure that what we do doesn't affect the rest of the state in an unexpected way, and that State Road and Tollway Authority and the Georgia Ports is on my mind right now.
And I am, as I think about it with you, I'm very happy to consider a suggestion that they should not be part of this bill, that this should only be local development authorities that are in the nature of traditional development authority. I mean, Fulton County Hospital Authority issues bonds. So, I mean, I'm very happy to discuss with you where the line might be drawn if that is on your mind. I'm thinking about individuals, entities that are in the more usual categories.
Yes.
Many development authorities entering into many bond validation hearing courthouses where the school system is told they are not allowed to participate, or the adjoining city. I want to make one other point about transparency in response to your question. There is no requirement that a development authority tell the world what deals it has already negotiated and finalized. There is an enormous amount of secrecy. Now, developers tell me that that's not how they operate. They always share what their plans are with the local school system and the local city, and that they are good neighbors, and that good neighbors are what make good development. I'm happily willing to agree that that's true, a substantial most of the time. But I also have very specific knowledge that development authorities do not always share information as good neighbors. And when they fail to share information with their neighbors, like the school system, or like the city adjoining their development, then I think that's wrong. I think that the school system and other local governments should have a right to come to court and say, this development deal hurts my entity, just as any citizen should have the right to come to court.
Thank you, Mr. Chairman.
Mr. Chairman, would you like to hear from witnesses at this time? I'll proceed in any way you'd like to.
Yes, ma'am. Thank you, ma'am. Any other member have any questions? At this time, let's see, Kathleen Bowen, would you like to come up to the microphone, please? If you'll step to the side and let her use the podium, please, ma'am.
Ms.
Thank you.
Bowen and she shared her amendment, and I'm very happy to accept her amendment if that's the will of the chairman.
Thank you.
Hello, I'm Kathleen Bowen, and I'm here representing the Association County Commissioners of Georgia. This summer, ACCG had a study committee to look at tax abatements and development authorities. So we have looked at these issues in depth, and we do believe it is a statewide issue. While DeKalb County is one example that keeps being brought up, we don't want what's going on in DeKalb County to be replicated across the state, and we do have instances where it has been. So ACCG is in support of House Bill 66. We think having the right to participate in the bond validation proceedings would at least allow a city or a county or the school system the ability to express their concerns to a neutral party. It doesn't give any local government or school system veto power. All it does is give them the same standing as a citizen would have or as that development authority would have. It cuts both ways. So if a county development authority was proposing a project that a city or school didn't like, they would have the ability to come and contest as well. So we do think it cuts both ways, and we think that it is a reasonable request to improve the tax abatement process. We do hope that by having this at the tail end of a deal, that it would foster better relationships and better communication on the front end. So hopefully we wouldn't even have to get to this point. I know there's great examples of development authorities in cities and counties and schools that do get along well and share confidential notice and share agreements and have plans set in place ahead of time. But that's not occurring all over the state. And personalities and city council members, county commissioners changes every 2 years. So we do think this is a good step in the right direction. We do have DeKalb County Commissioner Jeff Rader here that can put some more specific examples to that if you'd like to hear from him, or I'm happy to pause here and answer any questions.
Thank you for coming today. As I sit here and try to absorb this and ponder it and think through it, I'm not going to say that the revenue bond law in Georgia is a fragile thing, but it is a area of the law which has several cases that have built up over the last several decades that give us in Georgia really one of the best financing tools to be able to borrow monies for our citizens and build projects for them at really enviable rates, I will say, as compared to other states. From my knowledge, you hear quite often some reference to that when Georgia talks about how proud we're of our bond rating. In other words, we can borrow money because we have a good system set up, and the validation process you're affecting is part of that. So here's my thought. Why not try to amend the Development Authority's law to accomplish your goal rather than going into the revenue bond area, which, like I said, has several Supreme Court cases in it that have laid out a framework of how we do things. And every time you change the statutes, you possibly affect the good credit rating process that we have set up. And thus, if you go into the Development Authority's law and make your changes, you don't affect everybody else who has to use a revenue bond code. Just a thought.
Happy to consider that. I will say, when we debated that this summer, and the bond attorneys and those in the economic development world got very nervous about us touching or opening up that code section.
The
So
Development Authorities area?
the Economic Development Association, not association, but those in the economic development world.
They don't,
were
in other
cons-
words, they're saying the same thing I am. Be careful when you mess with this code section because the unintended consequences you could have.
Agree,
But
that's what,
but the
yeah.
problem here is with development authorities. They're not with school systems that use the bonding mechanism. They're not with the Georgia Ports Authority. I think they're not. I certainly have been down here for about 20 years, and I never have had any of my local governments ask me to introduce legislation in this area. I do admit that I know that Ms. Oliver is correct, that she's probably dealing with a problem out in DeKalb County that may work in other places. But what I don't want us to do is for these other members sitting on this committee, when they're in their communities, need the revenue bond law to do something that messes with it. And that's my concern.
Okay, we'll definitely look into that. Thank you.
Anyone else have any questions? Yes, ma'am.
Thank you, Mr. Chair. I just had a quick question. You did mention, I know that when we're thinking about this bill in the context of DeKalb County, it applies to what's been happening there, but you did mention this impacts other areas across the state as well. Can you speak to what that would look like or some of those instances?
We've had other instances across the state where a city development authority proposed to go out to bond for an apartment complex. And the county didn't even know that that project was out there until they read about it in the legal organ. Because in order to go out to bond, the development authority has to put a notice in the legal organ. So they didn't even hear about it or know this was in the works until they read about it in their newspaper. So it is happening, and that would have abated the taxes for the school system and the counties who have service delivery responsibilities to that entity. So we do have examples across the state. Unfortunately, the loudest ones and the most vivid ones are here in the Metro Atlanta area.
Yeah, thank you.
Anybody else?
Thank you.
Thank you. Let's see. Jeff Rader. Okay, we got Marshall Olson on Zoom. Oh, they're not there yet. Okay.
I think I'm here, Mr. Chair. Mr. Chair, can you hear me?
Jeff Rader, if you'd come up to the podium, please. Thank you.
I heard you, Marshall.
Okay.
Thank you very much, Mr. Chairman. I'm Jeff Rader. I'm a member of the DeKalb County Board of Commissioners for 14 years. And I represent unincorporated county and 4 municipalities. I wanted to talk first on House Bill 66, so I appreciate the opportunity. As Representative Oliver had mentioned, the first thing to know about tax abatement is that it is a derived power and that there are no statutory standards or restrictions governing its use by development authorities. You can contrast that with the much less powerful tax allocation district law, which requires a referendum, approval of all taxing authorities, and only affects incremental revenues. So I think it's important that we recognize that it is an inferred power, and I'm going to tell you how that happens. Tax abatement is a legal trick that puts income producing private property under the public title, but retains the income for private profit. Public property owners don't pay taxes, and since it's in the name of a development authority, the property becomes tax exempt. Once the development authority takes title, all taxes are extinguished, even those levied by governments unrelated to that development authority. So a city, for instance, whose taxes constitute only 6.5% of the total tax bill can extinguish the school systems and the county government's levy. If and how the property becomes taxable again in the future is spelled out in a contract between the development authority and the private developer. The other taxing entities are not at the table in the negotiation of that contract. In fact, the contract can cause the developer to share the spoils of the tax abatement with the development authority or its authorizing government, providing more income than their tax bill would, so that the government then gets more money than it would if it were a fully taxable project. The other governments are, of course, are the ones that end up holding the bag on that. But as was mentioned, these phantom bonds, and that is a term of art that the bond lawyers use, that make the fictional transfer to public tax exempt ownership must be approved by that superior court. Currently, those whose taxes are stripped have no regulatory standing to object. That's what 66 does, and it just gives the elected representatives of the people standing before the court. And that standing allows them to make legal arguments and to contest the merits of the bonds that implement the tax abatement. One useful improvement to House Bill 66 would be to require advanced confidential notification to the affected governments that the abatement is under consideration. If that were available, then those governments could work this out and negotiate their interests without having to go to court and without potentially muddying the waters when it comes to the jurisdictions, friendliness to economic growth and those other concerns that folks in the economic development community are concerned about, and rightfully so. But that advanced confidential notice would give us the opportunity to try to work it out between us. And if it were worked out, then the local governments wouldn't challenge the bond validation. That is the amendment, I think, that Ms. Bowen is proposing. Development authorities can and they should own property. Many of y'all have industrial parks and new basic employers like Kia and other major employers. That is part of the competition on an interstate basis to be able to give us an advantage in economic development. So there's certainly no suggestion that we ought not have powerful tools for being able to bring new jobs to Georgia. And an industrial park, I think, is really the purpose that these things most fit. But on the other hand, apartments and retail developments depend upon a local market, and other tax-paying businesses that are in the same business shouldn't have to compete with a subsidized competitor. So if you have an apartment complex and then there's a tax abatement on the apartment complex across the road, you're going to be competing with a guy that didn't pay in taxes. House Bill 66 is a good start. It can be improved, but I really think that the entire practice ought to be the topic of thoughtful study. Back to that first finding that there is no body of law that governs tax abatement as a practice and gives us public interest guidelines on it. As it relates to a couple of questions, the matter of the citizen standing only applies to a resident of the jurisdiction where the tax abatement is occurring. So if it were a city, a county commissioner who lived outside of that jurisdiction wouldn't even be able to stand as an intervener in their own personal capacity. And many county organizational acts, and certainly our ethics act, does not allow us to peer before boards in our personal capacity. So there is also, in some cases, an ethics concern about that. The simplest way is to clearly delineate the responsibility of the representatives of the taxpayers that are going to be paying the cost of the tax abatement, to be able to represent them in that particular way. And if there are any other questions or anything that was not clear from previously, maybe I can help you clarify those.
Does anybody have any questions for Mr. Rader? Seeing none, thank you, Mr. Rader.
Thank you. And are you going to take comment on the other two bills later?
We will.
Thank
Yes,
you.
sir. If we have time, we've got
All right.
1 hour in the room.
I
so
understand. Thank you.
We'll try. Thank you. Marshall Olson is on Zoom. He'll be joining us now.
Yes, sir. Thank you very much, Mr. Chair, and to members of the committee. Can you hear me? I just want to make sure. Can you all hear me? Hello? Can you hear me?
I hear you on the Zoom, Marshall.
Can they not hear me in the meeting room? Okay. Can you send a note to somebody, John?
There we are.
Okay. Can you hear me? Hello?
I sent a note to someone who's in the meeting. I don't know if they can hear either of us.
We can hear you now.
Okay. Can you hear me?
Uh-huh.
I feel like I'm on that telephone commercial. Sorry, Mr. Chair.
Go right ahead.
Thank you very much, Mr. Chair and members of the committee. I'm Marshall Olson. I'm a member of the DeKalb County Board of Education and the immediate past chair of that board. And I appreciate the opportunity to share with you today a few thoughts about HB 66, as well as potentially the other two bills. We're actually in the middle of our monthly board meeting, so I've stepped out for a few moments to share this time with you. I know some of the members of the House and those have spent a fair amount of time down at the Capitol over the last few years on issues related to protecting the revenues of not just the DeKalb County School District in particular, but on some issues that pertain really to any school district in which either annexations could affect them or development authorities operate within their same sphere of influence. You know, our request today and our support, my support of 66, and I'm speaking as an individual board member, but I can tell you that HB 66 in general comports with our legislative priorities of our Board of Education, is about ensuring that the revenues of school districts are not just wantonly diverted in a way that is at the expense and to the harm of children who attend our schools. And we know we are in particularly stressful times right now. Much of the first 3 hours of our board meeting have been in conversation about that, because we are being taxed as school districts with enormous responsibilities that really in some ways go far beyond what school districts have historically been responsible for. What has happened to date is that development authorities across the county, whether they are county or city development authorities, see that the use of property taxes can be an effective means for development. I respect the member who has pointed out that Georgia overall has had a successful history in this respect. However, the largest share of property taxes in almost every case are those that would go to a school district. And school districts are substantially funded by those property taxes. In a place like DeKalb County, the majority of our revenues come from those property taxes from our local assessments. So a situation in which we have no say or even input into what happens with those taxes really works at times to the great disadvantage of the children who we are serving, and really is a byproduct times of not just the necessities that may arise from the perceived notion of what's required for economic development, but quite frankly, also from the economic development competition that exists between and among development authorities. So we are often the only party that is affected that doesn't have a development authority. And I've shared with my friends, the Commissioner Rader, and I know that Mayor Ernst is on here, that perhaps school districts need their own development authorities. We could turn the tables a little bit, and then we might have a different perspective at times. And what we are asking for is the opportunity to make the case without a question as to whether we have standing, as to whether the particular incentive offered at one time is really material to the development scheme that is being proposed? And is it more important than the potential impact on the revenues to the school district? And that's I don't mean to oversimplify our position, but that's really what sits at the base of this. And I understand the arguments that often come that sometimes these are developments for which there may not be even existing tax revenues. But that presumes that every piece of property is of equal value or would not be developed. So if I had a piece of property sitting right there at the intersection of Peachtree and Ponce de Leon, it's probably pretty valuable, with or without an incentive that's attached to it. And without the ability to intervene and make an argument as to whether that incentive is necessary and proper and is economically beneficial in contrast to the cost that would be a result of that incentive, school districts are really left in a position in which they have no ability to protect their revenues. It's for this reason that I think HB 66 is a very good starting place and would urge your support of passage of the bill.
Thank you, sir. I appreciate your input. Does anyone have any questions? Okay. Thank you very much.
Thank you, sir.
Martha Gross. Thank you.
Hi, Martha Gross, a mere resident, unincorporated DeKalb at the edge of Brookhaven. I happen to hold a master's in economic development and I'm a commercial real estate professional. And I can see that it's a very complicated issue on both sides. I'd like to suggest that even as with those qualifications, I am not going to stand up at a bond hearing, and I wouldn't even be allowed to stand up at a validation hearing for something outside of unincorporated DeKalb. So if a city did that, I don't have any standing. Even if I did have standing, I've got a life to lead in my business, so I'm not going to do that. What I would like is to have somebody that I can trust, whether it's the school board or Jeff Rader or somebody at a commission, to be able to speak with the interests of the overall community at heart, particularly the school and our children. Thank you.
Thank you. Kevin Shea.
Thank you, Mr. Chair. I am the president of the Georgia Economic Developers Association and just wanted to speak against this bill. The Georgia Economic Developers Association, or GEDA as some people call us, is a nonprofit individual membership organization with 700 members. We have members in over 3/4 of Georgia's counties, and about 2/3 of them are outside of Metro Atlanta. Most of the development authorities in Georgia are represented through our member development authorities, through our members. Development authorities are critical to Georgia being #1 state for business, since most all state and local incentives go through these entities. Our top legislative priority for this year and for the past several years is to maintain local control and flexibility for development authorities. We are very grateful to Chair Oliver for her time on a Zoom call last week or a couple of weeks ago with GEDA leaders. And we shared our views and we were listened to, and Chair Oliver did the same. We primarily discussed HB 66. We have some serious concerns about that one, as well as HB 24. But for right now, I'll be speaking about HB 66. First off, we feel that this is a local issue and should be addressed as such. When the state law is changed to suit a particular community, many other people and organizations are affected negatively, or certainly could be. Most of our member communities deal with these issues at the local level without a problem. GEDA would encourage the chair to pursue a local bill, since her jurisdiction is only part of the state and is trying to apply a one-size-fits-all solution when it is not necessary. In almost all other communities around the state, there is communication with community leaders, including the school boards. There is also trust. The standing issue in HB 66 would negatively impact economic development projects due to possible delays in site selection projects timeline, especially if this were extended to all development authorities in the state. and very real possibilities of loss of confidentiality, which would kill a project for a community in most cases. We feel strongly that standing already exists by residents of the community that are on the school boards who can speak up on their behalf. We appreciate the challenges that are faced in counties throughout Georgia, but GEDA would encourage these issues be addressed locally with good old-fashioned leadership and communication. It has worked well for most all communities in our state with little or no issues. Thank you.
Thank you, sir. Does anyone have any questions? Thank you, sir.
Yes, sir. Thank you.
Does anyone else here wish to address the Committee on 66? Okay, thank you. And this hearing today is just for hearing only. We're not going to be taking a vote on any of these issues today. Chairman Oliver, would you like to proceed with 23?
Thank you, Mr. Chair. I'm happy to have a hearing only today because this is a very complex area. And the entities that are before you today are substantial and important entities for Georgia. Bond lawyers rule the world, Chair Fleming. That's one of the things I have learned in my long career, legal career. They rule the world. And when you enter their realm, you've got to have a serious discussion. If I may, Mr. Chair, I would like to, the County Commission, since we're in discussion mode for how we will move forward with various ideas, I'd like the committee to have the benefit of the ACCG amendment at this time, and I will hand it to Mr. Other than the bond validation hearing before the Superior Court that we've been discussing, there's one other legal proceeding that allows a discussion about annexation and possible development deals, and definitely a rearrangement of tax revenues for the purposes of a wide variety of reasons. Title 36 includes a provision where if a city is annexing a portion of property outside its borders, that the county specifically is given the right to object and the right to participate in a arbitration panel that is created and managed by the Department of Community Affairs. This proceeding, which gives counties the right to object to annexations, was negotiated between GMA and the County Commission Association within the last 10 years. I'm not sure exactly when. And they have been utilizing this procedure, and I think in a positive way. And some of the significant financial issues about an annexation that could be in a commercial area with high dollar values, like some of those set forth in my district. For instance, the $1 billion CHOA development is in my district that was annexed into the city of Brookhaven. The $1 billion Emory University expansion that was annexed into Brookhaven is in my district. And the $8 billion entity of Emory University, CDC, Federal Veterans Hospital that was annexed into the city of Atlanta is in my district. So we're talking about serious money and serious movement of tax revenues. Even though you may think of CHOA and Emory University as nonprofits, they are containing substantial private entities also that pay substantial taxes. House Bill 23 grants again to the Board of Education and any local school system the right to object to an annexation and a right to participate in the arbitration panel procedure. And it is fairly narrowly drafted only for that purpose. And the standard by which the school system would present its case to the arbitration panel is the use but significantly impacts student capacity of schools servicing the area to annexed. Clearly, if there was an annexation that took in a whole lot of children, and all of my schools in my district are overcrowded in the 3 public school districts in my district. They're all overcrowded. They're all popular and overcrowded. that is clearly a basis for a school district to have a right to participate in the dispute process that's set out in Title 36. House Bill 24 goes a little bit further in relation to this annexation panel proceeding. We know that some of you as local officials may have participated in some of these annexation panel dispute resolutions. DCA is required under the current statute to have a list of participants who would serve as panel members to hear these disputes. And it's a volunteer activity, and it is an activity that doesn't come with any kind of staff of any kind. I have met with the lawyers for the city and the county in a specific large dispute over an annexation, and they helped me a great deal in talking through the procedures of these volunteer annexation panels. And it brought me to suggest some of the changes that I think the law could enhance those procedures. For instance, I would like the panel to have the right to have the benefit of legal expertise, because the volunteers may or may not be lawyers, to help them manage, which may be a several-day process on a dispute about evidence, what to consider, what not to consider, and how to manage simply the process of that. The hearing officer, as an addition, which the panel of hearing officers would be private citizens, not state employees. They would be paid for by the city and the county. This is not an additional cost to DCA, and they would be of assistance to the panel to the extent the panel would like to make their use. I'd also given the authority to DCA, Department of Community Affairs, and I've discussed this with Commissioner Nunn and the gentleman that runs these probably dozen plus, but somewhere between 10 and 20 of these dispute panel arbitrations they've had, about their ability to issue rules and regulations to make a little bit stronger possibility of participation. So 23 allows the schools to participate in the dispute process, and 24 expands some of the procedure that will strengthen that dispute arbitration panel. The other part of 24 is disclosure of the tax abatement, tax incentives that are frequently part of annexation. And what the ACCG amendment, which I handed out to you for your consideration, combines in 66, the two provisions, the declaration of the tax incentive, tax abatement aspects of the annexation in the bond validation hearing, as well as in the panel arbitration. So, Mr. Chairman, in summary, again, these three bills are to create greater transparency and greater for the public, whether it's a citizen like Ms. Gross or a business person like her, or and to give standing to the school system or the other cities that are impacted. We know this activity, which comes out of a strength, it comes out of an economic strength, economic proposals, economic realities of growth and incentives for profits and new development, is positive. We just have to make sure that the right people are in the room to have the discussion about how the possibility of this annexation or this bond validation or this development deal impacts everybody. The developers have obviously a real interest in this legislation. They're appropriate for them to be here. If it were true that all development authorities and all developers are good neighbors and share their development deals once they're negotiated, not as being negotiated, but once the deal is developed, then perhaps this bill wouldn't be as necessary. But given the level of competition across our state, given the many areas of economic growth and economic opportunity, I believe it's time to update these procedures and make sure that the other impacted governments at least have a right to participate in the court legal proceedings. The question I've asked many people, developers, counties, and cities, do you want the only method of resolving a dispute that is going to arise in relation to annexations or development tax and benefits to be litigation. Is that the only way you want to let this dispute be resolved? Been a litigation lawyer for many decades. It takes a long time and it costs a lot of money. We should not be litigating whether or not, in my opinion, what the bills of this opinion set, the bills set forth, we should not be litigating the right of a school system, the right of a city to participate in a discussion about an either annexation impact on them or a tax abatement development deal that impacts them. Mr. Chairman, thank you. I'm happy to answer any other questions or proceed in any way the chair would like.
Thank you, madam. Anyone have any questions? Thank you. We do have Mayor John Ernst. I think that's how the mayor of Brookhaven join us from Zoom.
Unfortunately, he actually had to drop for another meeting. I'm more than happy to go with GMA.
Okay,
If appropriate.
sure.
We were going to tag team. Good afternoon, Chairman Williams, members of the committee. I'm Charlotte Davis. I represent the Georgia Municipal Association. And first, before getting to our specific concerns about House Bill 23, I do want to recognize Representative Oliver and thank her for the time she spent in reaching out to us prior to pre-filing her legislation. She actually was one of our featured speakers at our most recent municipal summit, and she got to hear some of our concerns firsthand. But I do appreciate her being open to this conversation. In the vast majority of cases, the annexation process that's in current statute works well. Residents and property owners can petition the municipal government to enter the incorporated area, and at that time, the municipal government will notify the county, and the county does have the ability to object, but in most cases, they don't, and the annexation proceeds and the property is moved inside of the city. Specific to House Bill 23, though, currently school boards have no standing in annexation disputes, and there's a reason for that, because school boards have no land use authority like a city or county does, both by the statute and the Constitution. The county does have the ability, though, in current law to object to an annexation petition if there's a change in the land use or zoning, the density, if there's a change in infrastructure demands, or in this case, what's being brought into House Bill 23 would be an impact on school capacity. But again, all of this would be in the context of the current annexation process. And the concerns that we have about this proposal are allowing a school board to interject in, again, what is a routine process when there's a perceived significant impact on the student capacity of schools serving that area to be annexed. And it's important to recognize, though, that even if the area is being annexed, in the vast majority of cases, we heard 21 independent school systems, the students are still going to be in that county school system. We also have concerns about what standard is reasonable for significant impact. Are we talking about a 10% increase, or are we talking about a 1% increase? And by granting the schools the ability to object, again, in the routine annexation process, without defining what significant impact means, we're of the opinion that's only further going to hold up what a routine process is. It's only going to make arbitration panels more contentious and then further appeals to the Superior Court. Currently, aside from the annexation process, though, cities rezone properties all the time. And this is a process, like I said, that's separate from annexation, but it allows new development to occur. And some of those do impact school capacity. But school boards already have the ability to come to zoning hearings, their public hearings where they can testify, and they also can work with their locally elected officials, and that's both at the city and the county level, to find the best ways to address the growth, which is very specific to this DeKalb County issue. But again, tying school capacity to the annexation process is not our preferred method. School boards, as we know, are independent bodies from city and county operations. They can redistrict, they can close facilities, and there's nothing that currently mandates them to notify a city government. But that's because a city is also responsible for preparing for increased density. They have to properly manage growth, and they have to be responsive if the school footprint changes in any way. Just as the school system, in our opinion, needs to be responsible for managing and anticipating growth. We've heard that this is a very specific issue to Brookhaven and DeKalb County at large. That's actually why Mayor Ernst was going to be able to join us, because it is very specific to the jurisdiction that he represents. But the bill as written impacts all our city governments, particularly any that are looking to annex in the future. as well as residents that are hoping to petition their municipal government to at some point enter into the incorporated area. Again, the majority of annexations are not contentious. We've had DCA reported they've had about 5 or 6 actual disputes on annexations on average per year. We've talked a lot about what we are trying to litigate through these bills, but it seems that a huge component is cooperation and working together with local entities. And that's something that, as y'all know, is very difficult to litigate. And we believe the process here of tying the two together is not going to help cooperation. If anything, it's going to make it more contentious. Mr. Chairman, that would conclude my comments on House Bill 23. We do have comments on 24 too, but be more than happy to follow your lead.
First, does anyone have any questions on that? If you will, go right ahead then.
Okay, we already talked about this a little bit, and I apologize because Mayor Ernst was actually going to be able to join us to speak on this bill too, but the majority, as the committee has already referenced, the majority of economic development deals are handled through a development authority and not a municipal government. And that's not addressed in 24. And the biggest pushback we get from talking about this legislation with our membership is that nothing in it would require a county, specifically an unincorporated area, or a development authority to notify a city when tax abatements are being offered. And I understand there was an amendment brought in this committee on 66. We were not aware of that amendment prior to it being brought, and we will need to study it a bit more to understand the impact. But that is one of our concerns. And again, with this, the current annexation process, we are of the opinion works well. Tying it to a tax abatement process, again, when it's associated with an annexation, is not only a rare case, but it's going to slow down a routine process. Representative Oliver was correct in stating that we don't actually have a definition in code currently for tax abatements. We don't have a great hold on what those mean and perhaps all the impacts on them. But because we don't have a consensus on something that is very legally challenging, it's even more reason why we would not prefer to have it attached to the annexation process. And I think as the committee probably realizes, most annexations either don't come with tax abatements, or if they do, they're not nearly as contentious as perhaps issues that have passed in DeKalb County or have gone to arbitration panels. I do think, though, that this particular discussion around tax abatements is what our membership would be the most open to having, and really want to keep the conversation going with Representative Oliver to study the impacts of tax abatements a bit more. But again, our association would not be able to support that in the context of the annexation law.
Thank you, ma'am. Anybody have any questions? Okay, Mayor of Brookhaven is back with us now, so we'll let him join us.
Thank you, sir.
Thank you.
Thank you very much, Commissioner. My name is John Ernst, Mayor of Brookhaven. I get to see a lot of good friends on Zoom and here in the hearing. I'm here to speak on these bills that are come out of a lot of stuff that is happening between myself and DeKalb County, a city in DeKalb County. But there are important issues that need to be discussed on a statewide basis. As far as House Bill 23, whether the school system could be involved in an annexation, I'll be honest, that's not my issue, though I'll directly, because I have no school system in Brookhaven. But I can tell you that is the number one issue why DeKalb County continues to have problems with annexation and such. That's the number one issue that is holding up and a lot of the discussions and around annexations in new cities is the school system issue, having basically 3 school systems potentially fighting over students and land and monies is the number one issue that is driving a lot of the angst, and is the number one issue that's holding things up for a final solution of some sort in DeKalb County. So, again, I think that is, I support GMA in saying that 23, needs more work and can continue going, something to continue discussion. 24 comes directly out of an annexation that Brookhaven just did. And the only reason why because it was an issue is because there was rezoning. As a part of our rules, any rezoning that could potentially have a tax abatement, we have to, the person has to disclose that they are potentially going for a tax abatement, not that there's a tax abatement actually occurring. And so that was, deemed as a problem. Again, that's the only reason why this has come up is because of our own internal rules. I don't think it needs to be a part of the annexation process itself. Again, that piece of property has yet to be, that has come into our city has not been given a tax abatement. There's still ongoing discussions and actually cooperative ongoing discussions with the county and the city on that piece of property. I know you guys spent a lot of time on 66 and I wasn't signed up for 66. I will speak slowly a little bit on 66 here, that there needs to be some guidelines, a working group that needs probably established with the State Department of Development, GMA, county association, school boards, Metro Chamber, Council for Quality Growth, other organizations out there to kind of have some guidelines around taxing authorities. I think 66 can be a good start, but I can tell you it's not necessarily about the whether or not a school board or a county commissioner can object or a city can object and be in that hearing. That's not the end all and be all. Once they have standing to object, they also have standing to appeal. And we did just lose a tax abatement process where the school board was allowed in, and we the development collapsed once that occurred, because they believed that once the school board was let in, that they have the rights to appeal, and there would be multiple years before that property could be solved. They subsequently, like I said, has discontinued the project. It is off. That project would have provided 5 times as amount of money for the school board than the land currently holds, and it was not a part of the annexation. So once you allow the school board and county commissions to be in, or cities, there will be a jockeying of filing objections, and then going through the entire appeal process for multiple possible years through the Supreme Courts. And in the background, all along will be what can the county commission, what can the city, what can the school board get and negotiate in bad faith. One of the projects I've mentioned that's been talked about was actually the county commission, or in that area, actually asked the development in question whether or not they would like help. And so they were actually looking to abate those taxes, and that developer believes so. So we would have these issues. It's very hyper local, I'll be honest, here in DeKalb, that it would be a competing interest. Thank you so much for allowing me to speak.
Thank you, sir. Appreciate it very much. Does anyone have any questions of the mayor? Thank you, Mr. Mayor.
Thank you.
At this time, I think we've covered everyone. Chairman Benton, would you like to present 221 at this time, please?
Mr. Chair,
Yes, sir.
this is Marshall Orson. I was wondering, I don't know if Representative Oliver was able to communicate. I had a few comments on 23, if that was okay.
I didn't hear the question. Okay, Mr. Chairman Benton, if you'll give us just a moment, go right ahead, Mr. Orson.
Okay, thank you very much. I just wanted to make sure that I shared with you, Mr. Chairman, and your committee, that 23 is actually a very important bill. I think it's unfortunate that the perspective from, and I appreciate it from the Georgia Municipal Association, that this is just a byproduct of some of these annexations. When there are annexations that involve cities which do not have school districts, then there is not a direct implication to a school system, particularly a county school system. But when there are annexations by cities that have an independent school district, of which there are 20, there can be very significant implications, and they are not just about enrollment, but in fact, they are probably even more so about revenue. The Emory annexation is a classic example in which there were very few students that were shifted from the DeKalb County school system to the city of Atlanta, but upwards of $2.5 million a year in perpetuity are being shifted in terms of taxes. The current process doesn't have any place to account for them. And in fact, the lack of standing in a role for school districts has led to enormous amounts of litigation, particularly, and so that I know you all think it's often just DeKalb County coming to the well, but particularly in the city of Atlanta between Atlanta and Fulton County, of which there are multiple Supreme Court cases in it. And over the history of annexation, there have been multiple Supreme Court cases going back to 1916. As an elected member, and I hope I would share this with members of your committee, I find it a little bit disconcerting that most of the law in this area as it pertains to school districts is judicially made law and not legislatively made law. And the reason is, I think that people, when the laws were passed around annexation, schools were just really sort of a byproduct. People didn't really think about the implications of what happened. And so as a result, the whole system is predicated on judicial cases, again, going back to 1916 or 1918, and not about the legislature weighing in on what's a proper and fair outcome. And so this is not an issue limited to DeKalb County. We happen to have two independent school districts in our area, that would be Decatur and Atlanta, but other counties such as Hall County, which has both the Beaufort school system and the Gainesville city system within its jurisdiction. It's a very, very important issue. And I know there was a comment made by the representative from GMA about the sort of suggestion that school districts do things that others can't weigh in, like on closing some buildings or redistricting. But in fact, there is a legislative scheme that controls what we do about this. That if we were to close a school, you as a legislature have deemed in your wisdom that we are required to hold certain public hearings before we can make that final decision. And so what we're asking for at a minimum here is the ability to have a seat at the table when there are distinct and sometimes very damaging results that could happen from an annexation when that annexation takes place by a city with an independent school district. We think that's reasonable and fair because the net result, I can tell you that from almost virtually every annexation that has taken place by Decatur or Atlanta, the number of students that have been transferred to another system, therefore the cost of those students, have been far exceeded by the loss of revenue that we have suffered as a result of that because of the way we are predicated, as I mentioned earlier, on the property tax system, where most property tax owners are supporting our schools, but don't necessarily have children. So I would absolutely encourage you, your support and approval, particularly of HB 23. Thank you.
Thank you, sir. I appreciate that. Chairman Benton, if you would present your bill, please, sir.
Thank you, Mr. Chair. I want to present to the committee today House Bill 221. This bill, if enacted, would allow or would cause any local government that plans on establishing a planning commission or another appointed body to review or make recommendations on proposed zoning decisions prior to the governing authority taking action that will result in a zoning decision to that body will be appointed a member from the school board that is over that area. When we look at, and we all receive tax bills every year, the first thing we do is we open it up and we look and see what's my school tax. And yet the schools had no input as to any decision that was made that is going to affect them in having to raise the millage rate to pay for any additional facilities that might be forced to be built. I heard the argument a while ago that school systems can go to these meetings and voice their disapproval. Yeah, they can, but then that's it. It doesn't matter what they say, but if you give them a voice, at least that's in front of I think a whole lot more people that would understand where the school system is coming from, and the idea that school systems can plan for growth. Yeah, but when subdivisions are planned 200 or 300 homes to, with a build out in 2 years, there's no way the school system can plan for that, because you're looking at, they say 1.5 kids per house. I don't know which half of the kid we get, the top or the bottom, but it's one of those things that the school system is constantly playing catch up, because the idea that rooftops in counties and cities that have independent systems, that's what they need to do. And the idea that school systems would be allowed anything that is not given some other group. They're not being given a veto. They're given a vote on whether or not that zoning decision is a correct zoning decision, or that the idea of building a 200 or 300 house subdivision. I would remind you, in my small county, Jackson County, it takes a house in Jackson County right now over $300,000 to educate one child. And so you really start backing up on that, and it really puts a burden on the school boards. And so I would ask for the committee's favorable consideration on the bill. Be glad to answer any questions.
Thank you, Chairman Benton. Does anyone have any questions for Chairman Benton? Let's see. Mr. Chairman
That's me.
Collins.
Thank you, Chairman. So all you're asking for is for them to have a seat at the table.
Seat at the table.
Okay. I got you. I don't disagree with that.
Chairman Fleming.
Thank you, Mr. Chairman. Representative, so it doesn't actually have to be a Board of Education member, just someone the Board of Education appoints, correct?
That's correct.
Have you talked with your locals about doing this?
Yes.
What'd they say?
They were very much in favor of it. They're constantly playing catch up.
Well, I mean, there's a city involved here or a county involved here.
Well, I have 3 school systems in my county. I have one county system and 2 independent city systems. Only Jefferson Commerce have an independent system. All the other cities in Jackson County have the county school system. So no, I have not asked them about it.
And that was my point. I mean, right now, they could appoint, well, most of the zoning boards I'm familiar with, they can appoint folks from the jurisdiction. So they could appoint someone that the school board asked them to currently.
But this would be something that the school board would appoint to it, not a person that's being appointed to represent the school board.
So if John Smith, the school board wanted John Smith on the city's planning and zoning board, they could say to the city, will you please appoint John Smith? And the city could say yes or no.
Well, then if they said no, then is it going to have to be contingent on meeting the approval of the city or the county board of commissioners?
So if a city's charter currently calls for 5 board members, do you increase it to 6, or do they have to take up one of the 5 that's there?
I think that could be done either way.
Which way does your bill do it?
Which way what?
Which way does your bill do it?
It doesn't do it. It just says that one will be appointed.
Okay, thank you.
Thank you, Chairman Fleming. Let's see, we have Larry Ramsey from ACCG.
Thank you, Mr. Chairman, members of the committee. I'm Larry Ramsey with ACCG. Just to speak, it sounds like we've got a theme of intergovernmental cooperation or lack thereof today with the bills the committee's heard. But a couple of things I want to add on this particular topic, as Chairman Fleming had talked about, the way planning commissions are structured right now. We certainly have a division of labor constitutionally in the state about where the zoning power lies, where the education power lies, right? So the Board of Education is deciding how best to educate the children of the county or the cities. And then the counties and cities have the power to decide what zoning rules, what development rules are most appropriate in that jurisdiction. House Bill 221 would, as you know, allow the school boards to appoint a member onto the county or city planning commission so that they have a say in zoning decisions. But I would say there's no equality here as the bill as it's proposed, because on the flip side, counties and cities have no say as to where school facilities go. For example, it's the law in this state, as the courts have said multiple times, that school boards can place school facilities wherever they choose, that they're immune from zoning rules. So that can be placed anywhere they choose to put them. The courts have also said that when school systems decide to place new facilities, it's the burden falls on the county or the city to provide the infrastructure to serve that facility. So if it needs a new road, the county and the city has to provide the road. The water and sewer lines, the county or the city has to provide those sewer lines to serve that facility. Cities and counties don't have a say in either one of those processes. The point is simply that this should be part of a bigger discussion, that certainly local governments need to work together on developments and need to work with schools on impacts to school enrollment. Every zoning ordinance that I will say, wearing a previous hat as county attorney and working with various counties, every zoning ordinance that I've ever seen has among the standards, and state law does require you to have standards in exercising your zoning power, that one of the standards that local governments, counties and cities have to consider is the impact on public infrastructure from a proposed development. I looked at before the meeting, the Jackson County zoning ordinance is an example of that. It requires the county commission to consider the impact on public facilities, including public schools, of any proposed development. That is part of what happens now and should continue to happen. But again, there is no flip side there required from the school's perspective for them to work with counties and cities about where facilities should be placed. I think most local governments in the state do work through these issues on zoning and school development. And if there's going to be a discussion on this topic with schools having a say in the zoning process, when the schools themselves are not required to follow zoning rules, that should be part of a larger discussion about interaction where counties and cities have a say in where the school facilities go. So again, we're happy to have further discussions with the sponsor, try to answer any questions the committee may have. Again, I'm happy to answer any questions.
Don't seem to have any questions. Thank you very much.
Thank you, Mr. Chairman.
Charlotte Davis, thank you.
Thank you, Mr. Chairman. Again, it's Charlotte Davis with Georgia Municipal Association, and our concerns with this proposal are very similar to ACCG's and also similar to ones we've raised previously in this committee, where counties and cities are given land use and zoning powers, and the school board by statute does not have those same abilities, but this would give them, although only one, but yes, a seat at the table to review land use matters without necessarily any particular expertise in land use. The example that we heard was about a new, I believe, single-family home development coming into the community, but the bill is not specific to only zoning matters dealing with single-family homes or perhaps other developments that would directly be tied to school capacity. It's open to any zoning decision or land use decision that a city might review. A lot of city zoning matters are specific to purely that community, but the way the bill is written, it wouldn't just allow a seat for the independent school system that's perhaps located in that community and city, but it also allow a seat for the county school board to review city zoning matters. So you would potentially have a school board member who does not reside in the city, doesn't necessarily pay taxes in the city, and didn't elect the local elected officials of that city that would ultimately be making the final zoning decision. We talked about this a little in previous comments, but the reciprocal of this would be allowing a city council member or an appointed city member to sit and review school board matters or curriculum or education. And most of us would probably think that that was not necessarily a good public policy, or necessarily didn't have a need to do that because there's other avenues to have that sort of engagement. And as mentioned too, cities are right now responsible for servicing these school properties, particularly ones in their own city, for infrastructure, water, sewer. If there's utilities like gas and electric that the city runs, all of those are responsible. The city is responsible for doing that. And we believe that they should remain as the sole decision makers of those services. I agree, though, that we probably need to have more conversations on this, Mr. Chairman. That concludes my comments.
Thank you very much. Chairman Collins.
I just have one question. We've been kicking the heck out of cities and counties today.
And schools, to be
And,
fair.
And, you know, and one of the gripes I've had for a long time are the creation of police jurisdictions in schools. I mean, to me, it just seems like it's a duplication of services. At what point are we going to get tired of duplicating services? I see some jurisdictions that have, you know, county sheriff, have county police, they have city police department. Then they have a county or an educationally run police force. So any input on that? I mean, are these school systems that are creating these police departments within their educational institution? Are they having conversations with local governments and saying, hey, we're gonna set up a whole nother command center here and spend another $3 million to do something that's already being done in these counties and these cities? Do you know anything about that? I mean, just a question.
That's a great question, Representative Collins. And I'd have to say that you look no further than your school zone and speeding and running of radar, those types of issues you start to see where local government authorities can really clash heads and where in cases where they might not be communicating. But for the most part, and speaking solely for incorporated cities, that's one of the benefits to coming inside of a city, a lot of cases, that you have a police force that services that city and it's a more responsive service that you are paying for.
Thank you.
Thank you, Mr.
Very
Chairman.
good question. I think what we need to do is probably lock everybody in a room and let y'all figure it out. Does anybody else want to have any say? I thank y'all for your patience and I thank all of you for sticking. I know we went over time, but I certainly learned a lot and know if nothing else, this meeting will stand adjourned. Thank you.